Let's jump right into this explainer. If you're looking to absolutely master how the law defines its own terms and the exact rules judges use to decipher them, you are in the right place. We're going to take some notoriously complex case law and distill it down into clear, memorable rules that are rigorously structured for your exams. Ready? Let's go.
Here's our roadmap for this explainer. We'll briefly cover the purpose of interpretation clauses, the strict limits of the means clause, expanding horizons with the includes clause, the hybrid means and includes, exceptions and cross-borrowing, and finally, our default dictionary, the General Clauses Act.
Starting off with Section 1, the true purpose of interpretation clauses. You might be wondering, why can't a judge just grab a standard Oxford dictionary and read the law? Well, because statutes are incredibly complex edicts. An interpretation clause is built in to avoid, really cumbersome repetitions throughout a massive legal document. But more importantly, it locks in the legislature's true intent. It's basically an internal tool providing absolute precision to words that might otherwise be kind of vague in everyday conversation.
And the 1940 Canadian case of Knightsbridge Estates perfectly lays the foundation here. This gives us clear exam gold on exactly when draftsmen should deploy these clauses. They shouldn't just define every single word, right? These definitions are used sparingly. They signal when a term is taking on an unusual meaning, or they step in when a word has several meanings and the legislature needs to pick just one. Ultimately, it's all about avoiding repetition, allowing for abbreviations, and flagging totally novel concepts.
Now, you absolutely must memorize this core taxonomy of definitions. It's the ultimate anchor for your exams. The legislature has the sovereign power to artificially define a word, and courts analyze these definitions based on three specific legislative verbs: means, includes, and the hybrid, means and includes. And listen, each of these verbs completely changes how a judge is legally allowed to interpret the boundaries of a given word.
Let's move on to Section 2, strict limits, the means clause.
Think of the word means, exactly like a locked box. When a statute says a word means X, that definition is prima facie restrictive and exhaustive. It tightly locks the boundaries of the term. If a scenario or a specific item isn't expressly sitting inside that locked box, it simply doesn't count. The court absolutely cannot add to it using external logic or reason.
Let's look at this principle in action with the fascinating Indris Sarma case under the Domestic Violence Act of 2005. The act stated a domestic relationship means a relationship between two persons related by consanguinity, marriage, a relationship in the nature of marriage, adoption, or as a joint family. Notice that restrictive word means. Because of it, the court had to strictly limit a domestic relationship to only those 5 specific ties. As a result, they entirely excluded a live-in relationship that was deemed adulterous simply because it didn't fit perfectly into the nature of marriage box. The locked box stayed locked. No exceptions.
Which brings us to Section 3, expanding horizons with the includes clause.
So what happens when the legislature wants a definition to act more like an expanding balloon rather than a locked box? Take a listen to this landmark quote from Justice Grover. It beautifully summarizes how the word includes stretches a word's natural boundaries. When a definition uses includes, it becomes extensive. It preserves the ordinary natural meaning of the word, but then actively expands it to encompass things it absolutely would not naturally cover.
To really grasp the bizarre, almost magical power of the includes clause, let's look at the 1972 Taj Mahal hotel case. The hotel had installed sanitary and pipeline fittings, and they wanted a depreciation allowance under the Income Tax Act, which was available for a plant. Now, common sense tells us a toilet is definitely not a plant. But the statute specifically said plant includes vehicles, books, scientific apparatus. So the court held that because includes indicates such an unusually wide meaning, even tossing in books in there, sanitary fittings successfully fell right under the expansive definition of a plant. Wild, right? For your exams, you've got to be able to articulate this stark contrast. On one hand, you have the locked box of Indris Sarma, where means strictly limits the boundaries. On the flip side, you have the expansive, boundary-pushing inclusion seen in cases like Safdarjung Hospital. In that one, the court explicitly stated that it's highly inappropriate to put a narrow interpretation on terms of wider denotation when the word includes is utilized.
All right, Section 4, the hybrid means and includes.
This combination draws a hard, exhaustive line. It's essentially the ultimate fence. It encloses the ordinary meaning with the means portion, grabs specific additions using the includes portion, and then shuts the gate tightly.
Check out the 1982 Mahalakshmi Oil Mills case. The statute defined tobacco as means any form of tobacco and includes leaf, stalk, and stem. So, the big legal question was, do tobacco seeds count? The Supreme Court gave a hard no. Because the legislature combined means and includes, they created an exhaustive list. If they wanted seeds included, they had to specifically list them. Since they weren't explicitly in the inclusive part, they were completely excluded.
Moving to Section 5, Exceptions and Cross-Borrowing. Because we're dealing with the law, these foundational rules naturally have their own curveballs and regulatory escape hatches, and examiners love to test you on these. First up, sometimes includes isn't actually as expansive as it seems. In the Swapan Kumar Guha case, the definition of a prize chit was inclusive, yet the Supreme Court read it strictly, excluding recurring deposit schemes simply because they lacked the fundamental element of chance. Furthermore, courts will absolutely not let you manipulate definitions to dodge the law. In Vanguard Fire, an insurance company tried to pass a shareholder resolution to instantly shut down, arguing they were no longer carrying on the business of insurance just to avoid a fraud investigation. The court blocked it entirely, basically saying, no way, you can't use an artificial shutdown as an escape hatch to avoid regulatory scrutiny while you still have outstanding liabilities.
You also really need to avoid a very common exam trap: cross-statutory borrowing. It is highly hazardous to interpret a word in one statute based on a definition found in a completely different statute, unless they are strictly pari materia, meaning they deal with the exact same subject matter. You literally cannot borrow the broad definition of industry from the Industrial Disputes Act and casually apply it to a Customs Act case. Context is absolutely everything. Finally, we arrive at Section 6, the Default Dictionary, the General Clauses Act. As noted in the 2015 Keshivlal-Khemchand case, it's standard practice for draftsmen to include definitions. But what happens when the statute fails us entirely? When a totally vital expression is left completely undefined, it falls on the court to expound the meaning. But where exactly do they look first to prevent total legal chaos?
Well, to stop that chaos, courts turn straight to the General Clauses Act, or the GCA. This acts as the default dictionary provided for central acts. Think of it as the underlying operating system of Indian statutory law. As confirmed in the MT Khan case of 2004, the GCA is an external statutory aid that applies universally to any other instrument. Yes, even the Constitution itself, just to prevent ambiguity.
And the GCA can be powerfully simple in saving a case. Just look at Section 13.2, which simply states that words in the singular include the plural and vice versa. In the M.V. Mulason's case, the articles of a company refer to members in the plural, but there was only a sole surviving member left. Did the clause still apply? Absolutely. Thanks to the GCA, the plural word members successfully applied to the singular surviving member, completely saving the clause from becoming a dead letter. Real game changer there.
I'm going to leave you with this final provocative exam thought. Almost all interpretation clauses start with a hidden caveat, unless there is anything repugnant to the context. So if a statute strictly defines a word using a means clause, but applying that strict definition to a novel modern situation creates a completely absurd outcome, which should win? The strict locked box text or the presumed escape valve of contrary context? How far can a judge stretch that context before they're no longer interpreting the law, but basically rewriting it? Ponder that as you review this material, and you will be more than ready to ace your exams.